us on the next Legal Lines, we're going to have Stanford Bardwell. He's a former U.S. Attorney for the federal government, for the Middle District. That's here in Louisiana. He's going to talk about what the federal government does when they decide that an individual or a company may have committed a crime, how they investigate them, how they use the resources of the federal government, and how they use the grand jury. That's on the next Legal Lines. Locke Meredith. Welcome to Legal Lines. I'm Locke Meredith. We're pleased to have on the show today Stanford Bardwell. He's an attorney here in Baton Rouge and a former U.S. Attorney for the Middle District, United States Federal Court. Stanford, thanks for being on the show.
Good afternoon. Nice to be here.
Give us a little bit of personal history about yourself.
I'm a native of Baton Rouge. Went through high school here and spent 2 years at the University of Michigan as a sort of an experiment, but came back and graduated from LSU and went to law school.
What'd you graduate in?
My undergraduate's in business administration, and I was commissioned as a lieutenant in the Air Force through the ROTC program, which then required a deferment for me to go to law school. And so when I finished law school, I then went on 4 years of active duty in the Air Force as an attorney.
So you're JAG?
JAG.
Okay.
Worked on just all kind of stuff.
Like the TV show we see? Is it anything like that?
Not quite. No, nothing that glamorous. The Navy may do that, but not the Air Force.
So you graduated from LSU Law School, did a stint
in the Air Force, then returned to private practice here in Baton Rouge. Basically set up a solo practice in commercial transactions, real estate, business and estate tax planning.
Now, I understand you got other siblings with college names or university names. Is that right?
That is true.
We had Judge Fields in here earlier, and he's got 2 last names, and we've all got some odd names. What's the story behind that?
Well, I'm a junior, actually, Stanford junior, and which means my father was Stanford. But he married a lady named Loyola.
Is that right?
Which is, of course, a university name both in Chicago and in New Orleans. And they, before married, decided as a lark that, well, if they ever had children, they would name them after colleges. Well, they did, and they did.
So you got a sister named Harvard, is that right?
That's a boy. A boy named Harvard, a sister and a brother named Duke and Tulane. They're twins, actually. And then a boy named Princeton, and an Auburn and a Cornell.
That's so interesting.
Yeah.
Well, tell me about your stint in the private practice. You said you did those particular areas, and what happened next?
I did that for about 6 or 7 years, and then got sort of aligned with a major financial conglomerate here in the Baton Rouge area as a general counsel. It was an insurance company, mortgage banking, had television, radio interests, life insurance, and I represented them for about 7 years as their sort of, not house counsel, but I was outside general counsel.
I think you said you were also an assistant DA?
I was an assistant attorney general during most of that same period of time for the state under Jack Grimion. It was a part-time position.
We've had the Attorney General Richard Ayoub on, and so I guess that was his predecessor.
Oh no, he was. It was 2 predecessors before that, actually. I was in with Jack Grimion. This was in the early '70s, and there were only 2 part-time assistant attorney generals in the state. One in Baton Rouge, me, and a fellow in Shreveport.
So what did you do?
My particular assignment was as counsel to the Department of Corrections, and most particularly to Angola Penitentiary. I represented the state on any lawsuits filed by inmates or anybody associated with activities at Angola. And
so kind of defense?
I did defense work. I represented the state on deaths and injuries to inmates, either by other inmates or by machinery or by bad medical practices.
Interesting. Kind of different world, huh?
Yeah, very different world. Had a very different, interesting medical malpractice case up there one time.
And what'd you do after that?
Well, after that, as I was still working for the insurance company and their different interests, I had been working very actively in the Republican Party here in Baton Rouge in different roles, from grassroots, kind of working my way on up. But about in 1980, I worked in the Ronald Reagan campaign for president. Before that, I had been the Baton Rouge chairman for Ford Dole when he ran against Jimmy Carter, and lost, of course, but I was the local chairman for that. Then I worked in the Reagan campaign, and afterwards, when he won, I was one of 5 lawyers put on a committee to select the United States Attorney under the Reagan Justice Department. And in the course of that review of candidates and applications from places and people around the country, really, we had applications from California.
So you don't have to be a resident of Louisiana to be appointed the U.S. Attorney?
No.
Interesting. I didn't know that.
And in any event, the committee was not satisfied with the applicants and began sort of casting around within the committee saying, well, why don't you do it? Well, no, I'm busy. Why don't you do it? And it's sort of like I drew the short straw and said, all right, I'll think about it. And
so ultimately we're appointed by President Ronald Reagan.
I decided to do it and was honored to receive an appointment by the President, confirmed by the Senate, and served as United States Attorney.
Let's talk about that, because I'm not sure many folks really have an understanding, I know I don't, of exactly what the U.S. Attorney does. And of course, that's what we're dealing with is federal law instead of state law.
Well, one thing I want to make a distinction is you can't explain it by saying it's the same thing as the district attorney in your local county or parish, because it's broader than that. And it's broader than that because what it amounts to is it's the government's trial attorney in a given geographic area, both for civil cases and criminal cases. So it has both civil and criminal responsibilities.
Doug Morrow is our current district attorney
He is the
for East Baton Rouge.
state-level official for criminal prosecutions at the East Baton Rouge parish level.
And then we have the Attorney General, who is basically the state of Louisiana's attorney.
Yes, but he doesn't, interestingly enough, have original criminal jurisdiction. It's derivative. That means that under our Constitution in Louisiana, is this more than you wanted to talk about? The district attorneys in each of the judicial districts have exclusive original jurisdiction. That is, only they can institute prosecution.
They have the sole right.
Sole right to institute prosecution within their territory.
Okay.
They can cede that authority to the Attorney General in certain cases, either at their request or, as often happens, the Attorney General will come to them and say, there's something that's happening statewide or,
we want to get involved.
5 parishes wide or whatever, and we think it would be better for us to do it, and usually the DAs agree, but they have to agree. So, where was I going?
And so then the U.S. Attorney is dealing, he's basically the United States federal government's attorney in our particular area. All right, I want to talk about that on the next segment. I'm Locke Meredith with Legal Lines. We'll be right back. Welcome back to Legal Lines. I'm Locke Meredith. We're pleased to have on the show Stanford Bardwell. He's a former U.S. Attorney for the United States Federal Court here in Baton Rouge. Stanford, again, thanks for being on the show.
My pleasure.
Now, we were talking about the role of a U.S. Attorney, and we were distinguishing it from a district attorney and the Louisiana Attorney General. Basically, as I understand what you've told me is, district attorney has original jurisdiction. He has the right to pursue crimes in his area.
Right.
You have the right to pursue crimes on the federal level, and the state attorney general basically has to get permission from either of you two guys if he wants to pursue a criminal matter.
Well, he could only pursue, even if we gave him permission, at the federal level he couldn't do that.
Right.
He could do it at the state level. Largely, the state attorney general is involved in civil matters, whereas the parish attorney, district attorney is involved in criminal matters.
Okay.
Within his territory.
Now let's talk about the U.S. Attorney. What is it that the U.S. Attorney does? He handles both, as you mentioned, civil and criminal.
He is the U.S. government's legal representative and trial lawyer in the territory in which he's appointed. And let's stop a moment and just define that. There are 93 federal judicial districts in the United States.
Okay. Louisiana has 3.
Louisiana has 3. South Carolina has 1.
Based on population?
It's hard to explain, really. Let's don't go there. Politics is mostly what it's based on. That's the short answer. But anyway, with the fact that you have 50 states, and I'm telling you there's 93, then you can see that that's roughly 2 per state, and on the average, that's what most of them have. And they're roughly divided half, or north, south, east, west, or something. And so there is a territorial limit, which means you've got X number of parishes or counties. In this case, the Middle District consists of 9 parishes, basically Baton Rouge, East Baton Rouge, and the 8 immediately surrounding parishes.
And so the event over which the litigation occurs has to occur within those parishes?
Yes,
has
correct.
Some contact with those parishes?
That's right.
Okay.
And just to get past the civil question first, federal agencies that either loan or guarantee loans that are defaulted upon in the commercial banks call on the federal guarantees. The federal, like the Small Business Administration, takes back the notes and sends it out for collection. And the office nearest the subject property or the debtor is charged with
going to get the money.
Going to get the money. So they just file suit just like a commercial trial attorney in a regular law firm.
But now there's some high-profile stuff too.
And that's usually, of course, on the criminal side. And that's what most people associate with that office. I guess a distinction I would make, because I had to learn it when I got appointed, between the state and the federal application of its authority, is that the use of the federal grand jury as an investigative arm is so much more extensive than at the state level.
All right, so let's walk this through. Say somebody calls you up and says, Mr. U.S. Attorney, I think an illegal activity is taking place, and you take me from that point forward. What happens?
Well, depending on its nature, well, let's make an easy comparison. What it's not, if that happened in Baton Rouge, then the DA would either call in the sheriff's office or the police or the city police, but that's about his option. I mean, he does have some investigators, but they usually get in after the fact. Whereas the federal government has an alphabet soup of investigative agencies that have different criminal interests.
Unlimited resources.
Well, the FBI is the most prominently known one, but Immigration Service has a criminal division, the Customs Service has a criminal division, the Postal Authority has a criminal investigative division, you know, the Border Patrol. I mean, it just...
So you have to decide what particular agency would be the proper investigation?
You make a preliminary call on that, and you essentially call that agent in that represents that agency in this area, and you have a chat and whatever, and if there's something to move on, then you work out an investigative plan.
And they do it, or do y'all do it?
Well, it's kind of done in harmony, because what they can get by just knocking on the door, they get. But oftentimes they need some other power behind them, which is the use of the grand jury. And the grand jury has subpoena power.
And that's where you become involved?
That's where the U.S. Attorney's Office comes in. They will present the issue to the grand jury members that are sitting at the time who vote, literally, to say, all right, we think we should obtain the records from here to here of Mr. X in his business at this car dealership.
Now, you actually prosecuted, for example, I think, Edwin Edwards, is that right?
Actually, no. I never had the pleasure of that. But I supervised two extensive investigations, different investigations. One involving fraud at the state pension deferred compensation program level, and another one associated with Texaco and oil regulation and pricing problems.
And you used the grand jury in those particular investigations?
Yeah, extensively.
And so what you're able to do with the grand jury, you have to go to them and say, look, we think we need these documents, and they give you permission to issue a subpoena to get them?
That's how it works on paper.
How does it work?
And, well, in practice, I was the legal advisor to the grand jury, and so it doesn't take much persuasion.
They pretty much listen to what you
they pretty
suggest?
Much listen to what we're saying.
Now, how are the grand jurors chosen?
They are chosen at the federal, well, both levels basically, but I know more about the federal one, and it's at random. I think they use a base of either voter registration or driver's license, and there's a random. The computer does a random sampling of every 14th name.
So it's just anybody off the street pretty much can be chosen?
In the 9 parishes. Now, see, that's what's an interesting feature about the federal criminal process, and that is that you get a wider cross-section of a jury member, potential jury member.
So no particular biases from a particular region?
I think that's an advantage.
All right. And so the grand jury's picked. Nobody has any particular expertise. It's a random selection. And there are how many members?
23.
All right. And then they're basically the body that's supposed to make sure that y'all don't run ramshot over any particular individual or business or something in the investigative process?
That's a way to look at it. Let me make this observation. In the state system, at least in Louisiana's system, the district attorney has authority to charge a person with a crime on his signature, except for capital offenses, that is, those that will call for the death penalty. And when he does that on his signature, it's called a bill of information.
Okay. Y'all don't do that at the federal level?
The federal government the federal attorney has no authority to charge any felony on a bill of information. It has to be by a grand jury indictment.
All right. What I'd like to do...
All of our work is with the grand jury.
Let's keep talking about that in the next segment. We'll be right back with you because this is Legal Lines with Locke Meredith. Welcome back to Legal Lines. I'm Locke Meredith. Again, we're pleased to have on the show Stanford Bardwell. He's a former U.S. Attorney for the federal government in the Middle District. Again, Stanford, thanks for being on the show. We're talking about the federal grand jury process and how you as the U.S. Attorney use it. I think folks probably have an idea, but what we're talking about is an extremely powerful branch of the government with pretty much unlimited resources and to go after and look after and investigate anybody. Is that right?
That is right, and it crosses parish lines and even state lines, and that's what gives it so much more power and flexibility than the local district attorney.
In fact, this is the process that was used to convict former Governor Edwin Edwards and the Jim Brown, who's in prison currently, and numerous others, unfortunately, insurance commissioners and public officials. I mean, once they decide to investigate, they have the resources to go forever.
You know, I'm not going to try to pick the exact statute, but there's probably a state statute that, say, Sherman Bernard could have been convicted under in the state court by prosecution by the local district attorney. But they simply didn't have the resources to make the case and make the investigation work. So the federal government had to do it. I mean, it comes down to even as simple as not having budget for court reporters to take extensive, because the grand jury's deliberations, well, not the deliberations, but the presentations and discussions are transcribed.
Interesting. Well, let's take me through the process. So we've talked about the fact that y'all have unlimited resources to accomplish the investigation, that you can issue subpoenas, you have subpoena power, which basically means send us documents, produce witnesses, do whatever we need send us whatever we want.
And we send out, well, we don't really send them out. We think we have the power to do that, but we don't. We send out FBI agents or customs agents to go investigate. They actually, that's the subject of another whole program, because they've got their own bureaucracy and they do what they do because their people tell them to do it.
Now, once you get the information you want and you've decided that you've got a legitimate reason to prosecute an individual, what happens next? Do you present the information to the grand jury?
Let's then make the fundamental distinction. The staff attorney handling the case will write up a proposed indictment, that is a formal charge language, that covers the events that we think happened. On this day or between this day and that day, you did so-and-so. And that usually comes at the end of a fairly long period of time in which witnesses have actually appeared in front of the grand jury. The grand jury has looked at documents. So it culminates with this presentation of this proposed charge.
Now, after the grand jury has looked at that documentation, do they have to vote to go ahead and indict?
Yes.
That you can draw up the indictment?
Well, what we present to them is the proposed indictment, really.
And what does the vote have to be?
I think majority, and the quorum is 17 people. But usually you get a lot of people. But the point I'm getting at is that what they're doing is presenting a charge, and the reason it's called a grand jury is to distinguish it from what the trial jury is called, which is called a petit jury, which the petit is French for small and the grand is French for big, and that's what it is. The big jury only determines if there is enough evidence to suggest that the person should go to trial. They don't decide guilt or innocence. That's what
they're just saying there's enough evidence here to make us think we need to go ahead and have a trial on this to see whether the guy's guilty or not.
You know, in some formula language, you think that it's probable cause to believe that there was a crime committed and this is who did it.
Okay.
But now you understand there's no defenses presented.
That was my next question.
There are no defenses presented.
In other words, if you charge me with a crime and you go get a bunch of witnesses and documentation and send it to the grand jury, I don't get an opportunity to come in and say, wait a minute, that's not true, and here's why.
Well, yes and no. You are invited to appear. But to appear, you would be waiving your rights not to testify and incriminate yourself. So if you went in and said, no, I didn't do this, or I didn't sign this, or something, and we find out that you did.
Now you're in bigger trouble.
Now you're in bigger trouble, because now you're being charged with lying to the grand jury. So most people don't take the chance and go. So for the most part, nobody actually appears to defend themselves to the grand jury.
Do they have attorneys appear for them and monitor the process?
No.
There's just no involvement, pretty much.
No. There is a new provision in the state statute that allows a witness to consult with an attorney who must remain outside the room. But that's new in itself.
And so once the grand jury says indict and they agree.
And technically, we present the information, we present the piece of paper, and we leave the room. And the court reporter leaves the room. And the jury members discuss, and they have elected a foreman already. So if they vote yes, then the foreman signs it and calls us back in, and we'll go file it with the clerk's office.
And is that grand jury done, or do they got a bunch of other stuff they got to look at now? Different crimes.
They're brought in for a given period of time.
Are they compensated in any way?
They are. I don't remember how much, but it's
not much.
Small. It's a per diem.
Okay.
It's a per diem.
All right, and then once they decide to indict, the process is what?
Well, depending on the nature of the offense and the target, you'll either go arrest him or you will have been in touch with his lawyer and you'll have him self-surrender. That depends on risk factors. And then he's advised of the charge and bond is set and he's released or he's not released. And then a schedule is undertaken to get him to trial.
And then does the whole investigation process continue, and do the defendants then get to have access to the information that y'all have accumulated?
Yes, there are provisions in the evidence rules to permit them access to both incriminating but also exculpatory information. Any information that we've developed that may suggest that they're not guilty, we have to deliver it to them. So,
And then the matter is actually tried in federal court.
yeah.
And is it always to a jury?
Yes.
Okay.
Yes.
And
Always to a jury.
depending what happens there determines whether or not they're going to jail or not. Now, is there plea bargains often at that level?
Yes.
How is that decided?
Well, pretty much with just negotiation with the staff prosecutor and the defense attorneys, evaluating their respective strengths of position.
So they decide, they
sometimes
basically evaluate whether or not they think they're
they can win.
prosecutors.
Who's going to win? And just like any other compromise, you come to a decision.
Stanford, thank you
You
so
bet.
much for being on the show. I appreciate you being on it. Now, I understand that you're involved in prison ministry, which is interesting.
Sure.
Because you've been on the side, put them in there.
That's
We'll
been,
talk about
that's been
that
an
next time.
interesting contrast.
This is Legal Lines with Locke Meredith. Thank you for being with us.